Thank you both for being here. Mr. Secretary, one of the hallmarks of the early days of your leadership have been the need for accountability. And as you are, I'm sure, aware, earlier, about an hour and a half ago or so, I, along with Senator Tester, Senator Isaacson, the chairman, and others, have filed a Department of Veterans Affairs Accountability and Whistleblower Protection Act of 2017. And let me state at the outset that the purpose of this law is not simply to punish people. It is also in the best interest of the vast and overwhelming majority of the men and women of the Veterans Administration who do an excellent job. And one of the ways in which we recognize the great job they do is by ensuring that the people who either supervise them or work alongside them that are not performing and or worse, involved in misconduct, do not remain in place and impede their ability to serve. The bottom line is we want to give you the tools to hire and reward good employees who are doing a good job, but also the tools to remove, demote, or suspend employees in an expedited manner who are not fulfilling their commitment to our nation. One of the issues that has been debated in the last few days, and I wanted to get your opinion on it, is the burden of proof. As you know, under current law, the evidentiary standard for someone for poor performance is substantial, basically substantial evidence, the degree of relevant evidence that a reasonable person considering the record as a whole might accept as adequate to support a conclusion, even though other reasonable persons might disagree. That is the substantial proof, burden of proof that exists today for poor performance. For misconduct, it is higher. For misconduct, the current law says that you need the preponderance of the evidence, and it's defined as the degree of relevant evidence that a reasonable person considering the record as a whole would accept as sufficient to find that a contested fact is more likely to be true than untrue. Some people have said that's a 50% standard, substantial is 30%. I don't know if those numbers are really there. Our law, as you know, that we have filed, makes them both substantial. It keeps the current law on performance, but it lowers the substantial misconduct under the theory that misconduct is a lot easier to identify and a lot easier to meet quickly that standard, and not to mention some of the cases. So I would ask two questions. Number one is, in your view, what is the appropriate approach? Is it to leave as is, or to raise the standard on lower the standard on misconduct but raise it on performance? And second, if in fact your belief is that they should both be the substantial evidence model, if you have any example as to how the current standard, for example, on misconduct, has been an impediment to accountability and being able to function in your new role.
Great. Well, Senator Rubio, first of all, thank you for recognizing that the vast amount of our employees are doing terrific and heroic work and are serving this country's veterans, and we should be proud of them of the work that they're doing. We're talking here about a very, very small number of employees who have deviated and drifted away from the ethical and the responsibilities that they took on to serve our country's veterans, and no longer should have the privilege of serving in our system. In those cases, I wish it wasn't true. I wish today I could tell you I had the tools to do the right thing, to be able to remove those employees. I do not. So unfortunately, I need a new set of tools if I'm going to be held accountable for turning this system around and doing what we all want to do to serve veterans. So I thank you for introducing this bill. I think it's necessary. In response to your questions, which are highly legal and technical, I only went to medical school, not to law school. I can tell you that I need substantial evidence in both of those cases, in performance and misconduct. That if we move towards a different standard than substantial, it will be harder for me to do the right thing and to serve the system the way that it needs to be led. So substantial evidence, it's not my understanding it is mathematical. It's my understanding that it allows the court to interpret the rulings in a way that is deferential to the secretary, to the business. It takes we have to prove that it's in the agency's interest to be able to make a disciplinary action, where if we went to a predominant standard, that would be mathematical. You'd have to show that 51% of the evidence is in favor of a disciplinary action, and that would be a much longer process. It would delay our decisions from even where they are today. So I believe we need the substantial evidence.
If I may, Mr. Chairman, I know I'm out of time, but this will be very brief. In your time at the Veterans Administration, have you ever seen, or do you have any evidence of any instance in which supervisors or anyone in the agency has targeted individuals for dismissal because we just don't like them and we're going to make something up in order to get rid of them?
Well, we have seen cases of documented whistleblower retaliation, and we are not going to accept that among our supervisors. We will protect our whistleblowers. And so I think that's an important part of also what you're introducing. But I want people to understand, I'm not seeking this, and I do not support your legislation so that we can willy-nilly fire employees or allow supervisors to abuse our employees. This allows due process. I believe it's very important that our employees have due process, the right to pre-decisional appeals, the right to be represented by the union or their attorneys. But in the cases that, frankly, we need to make the changes in management or other changes, today I just don't have that ability to do it.